Welcome to propertylaw.com, the treasure trove of property knowledge in Singapore. We are your one-stop destination for breaking down complex real estate topics and boosting your confidence in property transactions. Chapter 5, we're tackling a topic that's crucial to any property transaction: the concept of a trust deed. But before we dive in, make sure you hit that subscribe button to stay updated with our latest content. In this video, we're going to dive into the concept of trust deed. Now let's delve deeper into the concept of a trust deed. A trust deed at its core is a contract. This contract establishes a fiduciary relationship where a truster, also known as a settler, gives a trustee the right to hold property and assets for a beneficiary. So, what does this mean exactly? In simpler terms, a truster is someone who owns a property and decides to put it into a trust. The trustee is the person appointed to manage this trust. The beneficiary is the person who will eventually receive the benefits of this property. Trustees play a crucial role in this relationship. They must be of legal age, which is at least 21 years old, and they must be of sound mind. This means they should be capable of making rational decisions, and of course, they must be capable of owning land. Additionally, there can be up to 4 trustees appointed either jointly or severally. This means that these trustees can act together or individually in managing the trust. Now, the trustee holds what is called a legal interest in the property. This means that they have the legal right to control and manage the property. On the other hand, the beneficiary holds what is known as an equitable interest. This means that while they might not have control over the property, they have a right to the benefits that the property generates. Creating a trust deed is a serious commitment. The trustee is entrusted with the duty to make decisions in the best interest of the beneficiary. If they fail to do so, they can be held personally liable for any breach of trust. In essence, a trust deed is a powerful tool that can ensure the proper management and eventual transfer of a property. It brings structure and clarity to the relationship between the truster, the trustee, and the beneficiary. With a trust deed, the trustee holds legal interest while the beneficiary holds the equitable interest. Did you know there are different types of trusts? Yes, indeed there are. Let's dive into the specifics of each one. First up, we have the inter vivos, or living trust. This is a trust that is created during a person's lifetime. It typically has a set duration before the property is distributed at a certain time. This type of trust is created through a lawyer and must be registered with the registry to effect the transfer. Next, we have the testamentary trust. This type of trust is created upon a person's death. The person who acts as the trustee is someone that the deceased appointed in their will. If the deceased did not leave a will, the trustee is appointed under intestate law. Finally, we have the public trust. This is a trust in which the trustee is appointed by the court. If a person dies without a will, the court will appoint a trustee, also known as an administrator, to distribute the assets of the deceased. During bankruptcy, an official assignee will act as a public trust to handle the bankrupt's assets. Now, who can be a trustee, you ask? To be a trustee, one must be of legal age, which is 21 years old, be of sound mind, and be capable of owning land. A maximum of 4 trustees can be appointed either jointly or severally. The trustee holds legal interest in the trust, while the beneficiary has equitable interest. These types of trusts serve different purposes and are used depending on the specific circumstances and needs of the person creating the trust. Whether they're planning for the future while they're still alive, making arrangements for after they've passed, or ensuring their assets are handled appropriately if they become bankrupt, trusts offer a solution. Different situations call for different types of trusts. So, whether you are a real estate agent, a property owner, or simply someone looking to understand more about trusts, I hope you now have a better understanding of the various types of trusts and their uses. You might be wondering, why create a trust in the first place? Well, the reasons are as varied as they are important. Firstly, consider a scenario where the beneficiary is underage. The minimum age to own property is 21 years old. Before reaching this age, an individual isn't legally permitted to manage their property. That's where a trust comes in. The trustee, who must be at least 21 years old, holds the property on behalf of the beneficiary until they reach legal age. Another reason for creating a trust may arise when the beneficiary has a mental disability. and is unable to make decisions for themselves. In such cases, it is crucial to ensure that the property is managed in a way that benefits them. The trustee steps in to make these decisions, always acting in the best interest of the beneficiary. Now, you might be thinking that sounds like a lot of responsibility for the trustee. And you'd be right. The trustee does bear a significant burden. They carry the legal interest, making choices that will impact the property and, in turn, the beneficiary. But this isn't a role to be taken lightly. If a trustee breaches the trust, say, by mismanaging the property or failing to act in the beneficiary's best interest, they can be held personally liable. So while a trust does place a lot of power in the hands of the trustee, it also comes with a great deal of accountability. The trustee must always act with the beneficiary's best interests at heart, ensuring that the property is managed effectively and responsibly. In essence, trusts are created to protect those who are unable to manage their property themselves, whether due to age or incapacity. They provide a legal framework that ensures the property is handled correctly and responsibly. This is why trusts are so crucial. They ensure the protection and correct handling of property for those unable to do so themselves. Creating a trust is not as simple as it sounds. It requires a set of carefully considered steps and legal prerequisites to ensure its validity. The first requirement is the certainty of intention. This means that the truster, the person who creates the trust, must possess a clear intention to create trust obligations. They can't just decide on a whim, they must have a well-defined purpose. The second requirement is the certainty of subject matter. The trust must be created over a specific property. It can't be vague or undefined. The property in question must be clearly identified and specified. This could be a house, a piece of land, or any other tangible asset. The third requirement is the certainty of object. The trust must be created in favor of a beneficiary. This beneficiary must be certain and identified. It can't be an unknown person or an undecided entity. The beneficiary is the person or entity for whom the truster creates the trust, and they're the ones who will ultimately benefit from it. Another key requirement is the constitution. A trust is created when the trust property is transferred in writing. This is a crucial step that formally establishes the trust. The written document serves as proof of the trust's existence and contains the specific terms and conditions of the trust. Then we have formalities. The statutory provisions regulating the creation of trusts must be complied with. This involves following specific legal procedures and adhering to the rules and regulations set by law. Lastly, there's the capacity of the truster. The truster must have the legal and mental capacity to create a trust. They must be of sound mind and competent enough to understand the implications of their actions. While establishing a trust requires several steps, it's a crucial tool in ensuring the fair and legal management of property. Trust is fundamental in real estate. It's about more than just good faith, it's about legal obligations and protections. Remember, a trustworthy real estate agent is your best ally in navigating these complexities. Thanks for watching, and don't forget to subscribe for more insights into the real estate industry.